I think you're being disingenuous, counsel, when you tell me that there's nothing pending. I asked you if there's anything pending. You're telling me there's no motion. That wasn't my question.
Welcome back to another fiery courtroom clash. Today's case, Patrick Torr versus Martin Yance. Lawyers already sparring over what's pending or not, and the judge isn't buying word games. Trust me, this one's loaded with twists, contradictions, and real stakes. Stay tuned on. Don't forget to subscribe for more dramatic breakdowns.
Now, the motions that were in front of Judge Jewell in the Wayne County Circuit Court have been disposed of. And there is now in this court for this specific property, the Circuit Court action in Washington County Court has been dismissed. Mr. Fair appealed. That appeal has been dismissed as well.
Is that correct?
No.
Here we go. Okay, what's not correct about it?
Judge,
I guess counsel's indicating to me there's nothing else pending except.
Judge, I filed my motion in front of the Wayne County Circuit Court judge that you were aware of that occurred the last time we were in court. There's been no change in that case today. No change. It is still before the judge.
Correct.
The Register of Actions had the hearing on both motions in front of Judge Jewell. There is nothing pending. There's no pending motions in front of Judge Jewell right now.
Here's the legal tension. Mediation hasn't concluded. Yet both attorneys argue over whether anything is pending. This is critical because pending motions determine jurisdiction and next steps. But how can two sides share one case and disagree so completely on procedure? What do you think? Confusion or clever strategy?
I have the Register of Actions.
But does it say something about what happened with the motions?
I filed the motion for enforcing the judgment that was dismissed. Mr. Fair filed the motion to enforce the settlement agreement as well. And I do have the order if Your Honor would like to see it. And in that order, it sent us back to Judge Hattie.
Sent you back to who?
Judge Hattie as a mediator, which has been unsuccessful.
So there hasn't been so there actually hasn't been disposed of.
No, it has not been disposed of, Judge.
But there's no pending motion either.
Yes, there is a pending motion because it's before Judge Hattie. And Judge Hattie hasn't concluded.
Let's quit playing semantics with this. Is there still a court proceeding going on?
Yes.
The court needs to enter a dismissal in Wayne County. There is no pending motion. The court indicates the case is closed, but there has not been a final order because the dismissal has not been signed yet.
No, Judge, that's not true. I filed my motion to reopen the case and to have the case remanded to Judge Hattie for mediation. That's where the case is right now. It's before Judge Hattie, who then, if and when he finishes his mediation, will do a final order to the circuit court judge, which has not occurred yet.
That's what it sounds like to me. Right, counsel?
That
was a question.
I didn't understand your question.
The order sent it back to the mediator that somehow either is going to give some recommendation or something to the Wayne County judge by which an order will then happen.
No, Your Honor, the mediator's been unsuccessful. There's no order that orders the mediator to submit an order. Which is what Mr.
That doesn't make any sense, counsel. And I'll tell you, I'm getting a little bit tired right now and I don't want to play semantic games here. There is no motion pending. I get that. Part of the disposition, or at least temporary disposition of that motion, was it sent it to a mediator, Judge Hattie, right?
Correct.
Judge Hattie, while you may look at mediation as having been unsuccessful, has mediation concluded?
Yes. We're
Boom contradiction alert. One lawyer insists mediation has ended. The other swears it hasn't. The judge, visibly frustrated, calls out the semantics. This moment reveals more than procedure. It exposes trust issues in court. If lawyers can't even agree on what's happening, how do they expect justice to move forward?
No, it has not concluded.
How do two people share a case and have no idea what's actually procedurally happening? Is there another date that's set before Judge Hattie?
No.
Mr. Fair?
He is waiting to see if we can settle so that he can do a final.
Okay, look, you know what, guys? Every time you come here, everybody just starts saying the sky's blue. The other one says it's orange. The other one's, and I'm getting sick and tired of it. I don't think that the questions I'm asking where the posture or procedure is in a case is a very difficult thing for counsel to ever agree on. But for whatever reason, you guys can't. I think you're being disingenuous, counsel, when you tell me that there's nothing pending. I asked you if there's anything pending. You're telling me there's no motion. That wasn't my question. Then, when I'm asking, has mediation been concluded? You're telling me yes, but there's no order concluding it, but the judge sent it to mediation. So here's what's going to happen. Same. So what's going to happen?
Here's the turning point. The judge adjourns until January 10th, demanding an official letter from Judge Hattie. Translation: no more excuses, no more half-truths. Either mediation is truly done, or these attorneys are wasting everyone's time. This is a rare moment where patience runs thin and accountability takes center stage.
Is I'm going to adjourn this matter, what is it, January 10th?
Yes, sir.
January 10th, 2025 at 2 p.m. Realize that he is retired now, but I need a letter or communication from Judge Hattie as to the status of mediation.
Thanks, Your Honor.
If I don't get that, just don't even bother showing up, either one of you.
Thanks, Your Honor.
Good morning, Your Honor. Edward Drukas on behalf of Benjamin Whitfield.
Your name, sir?
Benjamin Whitfield.
Thank you. You need to take your hands out of your pockets.
I'm in two different things. I'm in receipt of a bond violation report. My client is also at two
Yes. Which one do you want to deal with first?
regarding the bond violation report. I mean, I'd like to waive this up and go and deal with it in front of Judge Kunke. That would be
Sure you would.
what I would like to do, but
I'm sure.
regarding
Mr. Allen.
the positive tests, I'm not sure how the court would like to handle it.
Well, we might as well deal with the bond violation. I don't know.
There was a positive last Friday. It was negative, the test after that. I've discussed with him going forward that in order to try.
Well, let's get clear, Mr. Lucas. I mean, just so that it's clear. On November 6th, he tested, there's the THC that's in there, and I don't know whether he has a medical marijuana card. He does have a medical marijuana card. The problem doesn't become that, it becomes the cocaine.
Mhm.
And then, so then it disappears from his system, which it normally would if he's not using or if we don't catch him on the right date in terms of testing. But then almost exactly a month later,
He was positive.
again, for cocaine.
I have discussed with him getting an intake to determine whether or not what kind of services he could use going forward. I've discussed with him, and
Has he been in treatment before?
he has done treatment before. He had brought up Lincoln Behavioral Services. He was going to get in contact with them. His father is here today. I've also gone over that information with him. I think the idea is to get that intake here over the next week or so.
Well, why wasn't it done before? Why isn't, I mean, when it hits in November, and I'm sure he was using before then, why didn't he do something then?
Well, I wasn't in receipt of any violation reports until yesterday.
Right. But he knows he's using.
Mm-hmm.
So why hasn't he done something before then, is my question.
Your Honor, can I say something?
Probably not, but you already started talking.
I'm sorry. I'm his father. My name is Daniel Woodville. He reached out to me and asked me if I could, help him with this problem. And, he's trying. So I'm just trying to support him in any way that I can. He's working for me. He's got 4 kids, and just trying to do. I'm trying to help him, to get off the drugs and to do the right thing. He's been working with me since Sunday night. We've been up all night working on the small construction company, and I'm just trying to keep him busy and trying to keep him away from the people that he's.
I don't doubt your sincerity in doing what you're doing. I mean, as a dad, I mean, and I get you standing up because you're trying to figure out what you can do to make it right.
Yes, sir.
All right. The problem is he's got to make that decision. And I don't think that he has, through your best efforts. I don't think that he has. And the problem for you is that you can keep doing it. You can keep doing those things, like you said, keeping him busy doing this. But if he hasn't decided that that's what he's going to do,
Well,
it won't happen.
Well, Your Honor, I think he has, because him and I hasn't talked for months, and he's reached out to me. We had a bad falling out about this, and over the last couple of weeks, like I said, we haven't talked for months. So I think I do see him coming around. I'm not trying to mislead you or anything.
No, I don't think that you are, sir. I mean, what I'm listening to is the faith of a father. That's what I'm hearing. And that I don't have any doubt in. What you're telling me, I have no doubt in any of that. What I have doubts about is really what he wants to do. Okay? Because when I see testing like this, that's somebody that's going to kind of give you lip service, but isn't going to quite do the work. Because, young man, you're not set up in any treatment, are you?
No, sir.
Did you ask your attorney or anybody else to try to help you get set up in treatment?
No, sir. I'm taking.
What efforts have you made to try to get into treatment?
There was a step this morning, Your Honor.
Pardon?
There was a step this morning. We did discuss going into a treatment facility and getting an intake.
Oh, I get that this morning, right? But the test was a week ago, and he probably used before that test actually happened. The test was on the 6th. And nothing. His dad's been trying to do what he can do with him. Nothing. And it's not until he gets here this morning and he's facing something that he decides that I'll say whatever.
We talked about, we did talk about treatment. He said he'd be willing to.
Right. I'm not doubting any, sir. Understand what I'm getting at. I'm not doubting any of that. What I'm saying is, I can say I'm going to walk from here to there. Until I take that first step, I haven't done anything.
Yes, sir. Yes, sir. I'm not going to keep manipulating me or the court. If he doesn't go, I'm done with him. That's why we had to fall out. I told him I'm not going to be associated with this nonsense. And if he doesn't,
But get this, sir. And it's not your own fault.
I'm sorry.
It's not your fault.
Oh, yes, sir.
But what I'm saying is he's manipulating already. The only reason he has those conversations that he's having, and then the conversation this morning, is because he's caught. And he's still, although having those conversations, he gets here this morning, between then and now, hasn't done anything. Hasn't made that step. Then he gets here this morning.
Excuse me. Can I talk?
Yeah, go ahead.
What are you going to say?
I made a step by coming. A big one.
Oh, I know. But what I'm saying is that
I
step.
got here. I got right up, came to court.
But sir, listen. The choice on that is, yeah, you don't come today, you're going to get a warrant, I'm going to get you.
Right.
So that's just the cold-hearted reality of that. Okay, so I don't know how much of a step that is. If you think the step of walking in here knowing that you're facing a violation is tough, that's why you haven't done anything for treatment, because that's a tougher step. That's why you haven't done anything. And you will say and do anything not to do that. I've been dealing with addicts for a long time. Some of it your fault, some of it not your fault.
So
Go ahead.
just regarding the violation, at this time, I don't know if the court's going to remand him, whether they're going to.
Here's what I'm going to do. He wants to make a step.
Mhm.
He's going to tell me that he's doing it. He's trying to tell his dad that he's doing it. He's talking the game and not doing it. I am going to revoke his bond. I'm going to remand him. I'm going to set it for December 26th. In between then, there are individuals at the jail that can work on inpatient. He can work on inpatient with you to try to get him into a program. I will sign virtually any order if he will get himself into treatment. Because the cold-hearted reality is, as hard as dad tries, as hard as everybody else is trying,
I don't have.
one day somebody's going to wake up, this young man's not going to be alive. And then nobody's going to have another shot at it. I've seen it happen too many times.
Thank you, Your Honor. This will be adjourned to a PCC the 26th.
On the 26th, I'll adjourn this matter to December 26, 2024, 9 a.m. Defendant's bond at this time is revoked. And Mr. Drukas, if we get something, I'll consider release if we get something in place.
I'll keep in touch. Thank you, Your Honor.
Thank you.
Case adjourned, bond revoked, and stakes higher than ever. One man's freedom now hangs on entering treatment before it's too late. The judge's warning is chilling. Keep playing games, and the next chapter may be tragedy. Like, comment, and subscribe for more shocking courtroom stories, because justice never pulls its punches.